Under the DPDP Act 2023, regulatory obligations are not distributed equally across companies, but based on their specific risk profile. The law establishes the Significant Data Fiduciary, an elevated tier of classification designed for maximum accountability. This designation applies to organizations processing large volumes of personal data or managing information that intersects with national interests. This follows a proportionate model, where a small business and a large platform both share baseline duties, but face diverging requirements as their data footprint grows. The regulatory landscape is structured so that compliance obligations scale alongside the systemic risk an organization poses to the public. For corporate leadership, this structure introduces a specific challenge, determining if and when their organization will receive a government notification. This diagram illustrates the structural pillars of accountability required to balance systemic risk. These requirements involve dedicated personnel, independent audits, and formal risk assessments. Building these heavy compliance architectures after a mandate arrives is difficult due to the statutory timelines involved. Proactive structural preparation allows for the integration of privacy controls, whereas reactive retrofitting often leads to operational disruption. Readiness must be built into the organizational architecture before the government issues a formal mandate. To understand the operational impact, we must examine the legal mechanics of Section 10. Significant Data Fiduciary status is an externally assigned designation, rather than a voluntary opt-in framework. As shown in this process map, the designation is a top-down action initiated by the central government, following a formal assessment. The government can notify a specific individual fiduciary or designate an entire class of organizations based on their common processing activities. The state alone holds the authority to evaluate a company's footprint and assign the label. This matrix outlines the 6 specific factors the government evaluates before issuing a notification. The evaluation starts with the volume and sensitivity of the personal data being processed. It also includes the potential risk posed to the privacy and rights of the individual data principals. The assessment then shifts to macro-level factors, such as the potential impact on the sovereignty of India or the security of the state. Finally, the government reviews processing activities that could affect electoral democracy or the maintenance of public order. While scale is a factor, the government assesses risk qualitatively. Processing sensitive data or operating systems linked to national stability triggers maximum oversight regardless of total user count. Once an organization is designated, 3 specific statutory obligations take effect. The first requirement is the appointment of a data protection officer. This DPO must be based in India, report directly to the governing body, and serve as the point of contact for grievance redressal. The second requirement is the appointment of an independent data auditor. This auditor evaluates the organization's compliance through an external lens and reports their findings. The third requirement involves periodic measures, such as data protection impact assessments and recurring audits. A DPIA is a structured evaluation of processing activities and the specific risks they pose to data principals. These 3 pillars represent permanent structural changes to a company's governance. They mandate active, independent oversight of the entire data architecture. This grid shows where these designations are most likely to occur. Large consumer platforms and marketplaces are primary candidates due to the volume and depth of user data they manage. Financial institutions and telecom networks are also high-priority targets because of their national scale and links to public order. Specialized sectors like healthcare or AI development may also qualify based on data sensitivity, even if they serve a smaller user base. The designation follows the risk profile of the data itself, rather than standard industry categories. This 6-step framework prepares organizations for potential designation. First, map data volume and sensitivity against Section 10 factors. Then, identify an India-based DPO candidate and establish a repeatable DPIA protocol for high-risk features. Finally, ensure documentation is audit-ready and maintain complete data flow visibility. Finally, monitor for new government notifications and subordinate rules that will define the finer operational details. Early preparation ensures enterprise resilience by the time the government's oversight requirements take effect. Section 10 raises the compliance bar, but these obligations are manageable if they are architected into the company's governance early. For organizations reviewing their exposure, the appropriate starting point is a formal, structured DPDP readiness assessment. Second Quadrant Consulting Solutions helps teams evaluate status, define the DPO function, and implement audit processes. Subscribe to our series for more technical analysis of the DPDP Act. Our next video will provide a deep dive into data protection impact assessments. Under the DPDP Act 2023, delaying preparation until a formal notification arrives creates a significant and avoidable compliance gap.